Good morning, everyone. Wish to welcome you all here. We'll start with the opening karakia. Te wharo, I hope you'll help me through this.
Tui ki te mauri o te whenua, tuia ki te mana o te tangata, tuia ki te pono, te aroha, kia peki, kia eke, ki te taumata, hui e tai ki.
Just need to remind everyone we are being recorded and will be on YouTube. Welcome to today's council briefing. It's great to see so many members of the public with us today. This is the first in a series of sessions on the proposed joint management agreement between the Taupō District Council and the management agreement between Taupō District Council and the Tūwharetoa Trust Board. I asked the Chief Executive to bring this information forward so councillors and the community have a full understanding before any decisions are made. Earlier feedback told us the process felt rushed, so following the elections, we're taking a deliberate and transparent approach to ensure informed decision making. I would like us to look forward, not back. We are newly elected council, and consequently our focus should be on getting all the knowledge we need and working together to make well-informed decisions for the future. Today's focus is on the legislative context, which sets the foundation for future discussions. Additional briefings will follow in the coming months on other key topics relating to the JMA. This is an information sharing phase with any decisions still some months away. All councillor briefings, including today's, are being recorded and live streamed to ensure openness and transparency. The joint management agreement is required by legislation and is an important step in how council works with partners and the community. These sessions give everyone the chance to understand the framework, implication and next steps. Another reminder that in line with normal processes for council briefings, questions can only be asked by the councillors. I now hand over to the Chief Executive, Julie Gardine, to take over from here. Julie.
Thank you, Your Worship, and good morning, councillors, and equally a warm welcome to those in the audience and online for today too. So thank you for being here. I'm just going to ask if we could just turn the slide over. Thank you. So that is a summary of the key points from His Worship the Mayor in terms of that briefing. And then the next slide, if I can, thanks, just adds to the conversation that we've just had. So as His Worship the Mayor has said, we will be following a series of briefings. This is put up on the screen to give you an idea of the types of topics we are intending to cover in those briefings. As we've said, today is on the legislative context, and we're looking at least 4 briefings coming up in next year. So just to break down, they're not in order, but to break those down, just to give you an idea of what we are thinking, that's on the screen. But also we'll be looking at, obviously, the draft JMA that lay on the table from last triennium, so the mandatory matters. You can see down the bottom there the draft extension matters in a session separate. Community engagement and on our legal requirements on that. And then, of course, there's a lot of interest in terms of what's just come out over the last week or so with changes to the Resource Management Act. And given it's just come out, we haven't had the opportunity to look at that at this stage, so we're looking at a briefing at that next year as well. So again, councillors, it just provides some context about the process that we are intending to follow and go through between now and next year. It's my pleasure, therefore, just to flick, thank you, just to actually hand over to Paul Beverley. Paul is online with us this morning. He is on the screen there, I can see, fortunately. Just to introduce Paul, his bio's up on the screen here in front of us. But Paul has a partner at Buddle Finlay and specialises in this area of law, and particularly it's a great pleasure to have Paul here today because he was actually involved in the Waikato River arrangements, which is going to be the topic of today's briefing too. So thank you very much for making the time to be with us this morning, Paul. I appreciate that it has been a little bit challenging. It is the day that Air New Zealand cabin crew were looking at a strike, which is now being put back, but I appreciate for bearing with us in terms of making some of those arrangements. And over to Paul.
Paul, could I just interrupt? I need to record that Councillor Leonard has put an apology and Councillor Gridslade is online. So, Paul, it's all over to you.
Thank you, Your Worship. I'm just checking you can hear me okay? Yes, thank you. Thank you. And I'm going to share my screen. So if I could just first acknowledge Your Worship and the elected members and the Chief Executive and all of the council team. And I can't see the members of the public, but just acknowledging any members of the public that are in the room, and of course Ngāti Tūwharetoa as well. So I'll just share my screen if I may. I've just got a short presentation. It's a relatively short briefing this, but just to identify the key legal elements of that sit behind the joint management agreement. So again, if I could just check, can you see that presentation, Your Worship?
Yes, we can, Paul. Thank you. If you
Yep.
put it into presentation mode, we'll be fine. Thank you.
Did you say put it into presentation mode, or?
Yes, please, Paul. Can you just change the
You're gonna have
format?
you might have to tell me how to do that, Julie.
So I'll ask the other way. Is everyone okay with it as it is? Can we read it? It's down the bottom. There's the little presentation icon. It looks like a screen thing. We'll text you, Paul. You carry on. We'll text it. And we'll sort it out.
Okay. Sorry about that. Yeah, I had a team. I should do it as a slideshow, is what I'm being told. So I could do that. How does this might look a bit better? Is that a bit better? Can people see that?
It's much the same, but anyway, everyone can see it.
Oh,
People
okay.
nodding their heads,
Thank you.
holding their thumbs up. Paul.
Thank you very much, Your Worship. So just by way of overview, I'll just talk about what a joint management agreement, JMA, is, the legislation, the scope and content of the JMA, a couple of other matters, and then answer any questions. So the first thing is, what is the JMA? So the joint management, there have been joint management agreements provided for in the RMA for around since around 2005, but they haven't been taken up very much. Although Taupō District Council was the first council to take them up in the joint management agreement it did with the Tūwharetoa Māori Trust Board in 2009. But there hadn't been a lot of them taken up, and so through the Waikato River treaty negotiations, which at that time involved 5 iwi along the river, it was agreed that provisions would be put into the treaty settlement legislation to require joint management agreements between the councils and those iwi as a way of, it was one of many options for how you may formalise these agreements between councils and iwi, but that's the option that was taken, and there are joint management agreements all along the river and in a number of other places. There are similar agreements. The JMA provides for the council and the trust board to work together in carrying out functions under the RMA and other legislation. So it's really it's about how you work together, and they're intended to bring clarity to the council and the iwi and to streamline RMA and other processes. And I can talk a bit more about that, but really the idea is, in some ways, they often, these agreements give expression to existing legal obligations and just bring some more clarity to both the council and the iwi. For example, as you work through an RMA planning process, how you would reasonably work through that process together. There are already statutory obligations to work with iwi or consult with iwi, for example. So the agreements often seek to bring clarity for all and to the public about how people are going to work together. It's very important to say that if you and so, if I use other places that I work in with councils, if you took the JMA away, it wouldn't necessarily take a lot of the legal obligations away. So they're often for that purpose. It is very important to say that the joint management agreement that this council is considering and will make future decisions on with the trust board, it's not an RMA JMA, if I can put it that way. it is a joint management agreement entered into under the settlement. So I'll talk a bit more about that. So just the legislation in relation to this context, the Ngāti Tūwharetoa, Raukawa and Te Arawa Iwi Waikato River Act 2010 is the legislation that requires this JMA to be entered into. This council has JMAs with both Raukawa and Te Arawa, and as does the regional council, and the regional council has a JMA with Ngāti Tūwharetoa, which covers Lake Taupō in these areas. So there are other pieces of legislation that apply to Waikato and Maniapoto further down the river. So as I've said, the legal framework is this Act. It is not the RMA. And the first thing to note is that the JMA is compulsory under the Act. So the Act simply says it says it's a duty to make it, and the council is required to enter into this agreement within a certain time frame with Ngāti Tūwharetoa or the Trust Board. There are JMAs required under other settlement legislation, and if I use some examples, there is just recently 5 councils have entered into a joint management agreement with Maniapoto down the other end of the river, and that's between 5 councils in Maniapoto, and there are some similar elements. That's online, and there are some similar elements to this, to what this council's working through here. So if I may just talk about the scope and content of the joint management agreement. So what the Act requires is the JMA must cover the Waikato, and I've got some maps that the council team have provided to me, so I'll put those up in a moment. But what the Act says is the JMA must cover the Waikato River and activities in that catchment affecting the Waikato River. So it's a catchment-based joint management agreement. It may also cover the Taupo, in the case of this JMA, Taupo waters if the parties agree. So that was put in at the time to provide optionality both for Tūwharetoa and the council if they decided it would be sensible to include these other areas, and we can talk a bit more about that. What the legislation then does is says that the joint management agreement must cover certain compulsory matters and may cover other matters if the parties agree. And this is very common to the way in which these joint management agreement statutes work. So there are provisions in the Act that deal with monitoring and enforcement and set out in some detail the topics that the council and the Trust Board must talk about and decide how they need to be in the agreement. So, for example, discussing and agreeing priorities for monitoring, that has to be dealt with in the agreement. But there is scope for the Trust Board and the council to talk about how they do that. It's the same with planning, and there are a number of steps set out in this Act which, for example, require a joint committee to be convened so that the Trust Board and the council can work together in some of these important stages in the plan change process. Same in the resource. And the iwi will work together, the Trust Board will work together through a whole lot of steps like resource consents, thinking about what further information is required, notification. So the Act is quite detailed in that sense, but does leave scope and room for the council and the Trust Board to build on that. It's really just a starting point, and there are also processes in relation to customary activities. What the Act then says is the joint management agreement may cover other matters as the parties agree, additional duties, functions and powers as agreed under Section 54. And this is where the council, and if I use some examples I've worked on elsewhere, or even the mana whakahono that this council, which is another type of agreement, which this council entered into with Ngāti Turangi-Tongariro a couple of years ago. I'm just being told that you're operating my slides from there, so that's good. I'll
Yeah, all okay
Stop
at this
sharing
end.
those.
Yeah, all okay at this
Okay.
end, Paul.
You can see what you're doing. So I
yeah.
don't need to operate the slides. Yep, cool, I'll do that. In a number of places, what councils have done, including this council and the mana whakahono, or that other agreement I was just talking about, is to adopt an approach where a broader approach where the agreement deals both with the compulsory matters and extended matters, so that the council has one coherent agreement with, say, an iwi or the trust board or someone else, and these are matters you will deal with in your subsequent briefings, Your Worship. If we just take the example of the Maniapoto Joint Management Agreement, which is based on the same legislation but further down the river, that deals with a whole range of extension matters. So it's but because there was a desire to have a holistic agreement that that dealt with everything, so that you don't have an agreement dealing with RMA planning, but then you don't have any agreement dealing with local government act planning. So that's why this extension matters provision is in the statute. I will go to the next slide, which is legal framework and process. If I may just go to the next slide on from there. So the Act includes principles for the development and operation of the Joint Management Agreement, which include promoting the restoration and protection of the health and well-being of the river, respecting the mana whakahaere rights and responsibilities of the Trust Board, respecting the roles of the councils and other such things. And so there are principles applied. There is a committee convened to oversee the operation and delivery of this agreement, and there are a number of statutory steps for stepping it through. There are, in fact, escalation and dispute resolution processes involving the minister if agreement's not reached. So there's quite a lot of process in the Act as well. And then, as I've said earlier, the Act disapplies the RMA provisions, and that was an intentional step at the time to say these are not the voluntary sort of JMAs you can have under the RMA. This is a compulsory JMA provided for through the settlement legislation. So the RMA provisions that normally apply don't apply. There is no right of termination. The statute says there's no right of termination under the agreement except on extension matters where there is a right of. So if the council, for example, agrees to extend the JMA to Local Government Act functions, which a number of them have, there is a right of termination on those extended functions. So that's but there is a process that you work through before you do that. It is possible for the council and the trust board to agree to suspend some provisions in the agreement if there are other priorities. And there's also an ability for the council in urgent or significant circumstances to continue to exercise its the powers without complying with the JMA if there's a reason to do so in that circumstance. So just to summarise all of that, really, the approach of the legislation, there are some compulsory elements of it, there are some enabling elements of it, but it is quite a well-structured and process to ensure that there is a joint management agreement in place. It deals with certain topics and it deals with them in some detail. There's an ability to extend to other topics if that's what the parties agree to do. And it was really about, at the time when this was negotiated, it was about bringing some clarity to how you would work together through certain statutory processes. It doesn't take away power, doesn't take away the council's power, but it modifies it in a way where there's an opportunity to realise some of the opportunities that come through these types of relationships. So finally, as I say, I've done a number of these for a number of councils, so have seen the ways different councils approach them, but I think there are some common themes around the agreements being designed in a way that brings clarity both to the council and to the iwi about how these statutory processes are to be carried out. When they're successfully implemented, for example, you tend to find for all of the public and for everybody that there's more clarity and less there's certainly less opportunity for litigation or appetite for litigation if the processes are working clearly. So, Your Worship, I think that's all I had to say. Just it's a brief step through the legislative framework, but I'm very happy to take any questions if that would assist.
Thank you, Paul. Do we have any questions of Paul? Councillor Campbell.
Yeah, hello, Paul. Thanks for the presentation and the background. Thank you for being here too. Well, not here, but over there and here. Look, I have two burning questions really. One's the first an observation. Look, I've come across your 2015 paper, A Stronger Voice for Māori in Natural Resource Governance, and excuse me, where you state more than once, Māori have a deep and innate relationship with natural resources. Look, and it's repeated more than once. Look, I would respectfully suggest that is a value-based belief, certainly not an established scientific or legal fact, implying that Māori have an inherited or unique connection to nature than the rest of us who do not. So I want to call that out as a racialised idea that deserves to be acknowledged as such.
What's the question,
And I know many of our wider community will agree. That's my observation. This is my observation to start with. So I have a question, but this is.
Oh yeah, please. I'm very happy to respond to that if it's helpful. I certainly. That's not an observation. Well, the fact of that relationship is very well established and it's recorded in legislation in a number of places. I'm very happy to provide that to you, and I think it's incontrovertible, but it's certainly not suggesting that other people don't have deep and important relationships with natural places either. That's certainly not the case. But look, I won't debate the point, but it's important just to be clear on that.
So Duncan.
Yes, well, I'll move on to
Duncan, can we just interrupt there?
Oh.
We need to give some of the other councillors a chance. Councillor Foreman.
Kia ora, Paul. You pointed out that we have some compulsory requirements under the Act. Just wondering what was that time frame that the council had, and have we complied?
Thank you, and through your worship, so that the time frame is 18 months or such longer time as the parties agree. So I may have to draw on the council staff to remind me when this was actually triggered, but I understand the parties are in agreement, or at least when I was involved, we were in agreement that these matters, that this process could continue.
Councillor Murch.
Kia ora, Paul. I just had a question around the legislation that you spoke of. Given that the JMA is actually enabled by legislation, what's the legal justification for not adopting it?
Thank you, Councillor. Through your worship, there's no. Well, the council has to. The council has to reach agreement with the trust board and enter into it. The heading of the section is duty to make. That it's compulsory. There's no option if there's some optionality around the contents of it.
Councillor Campbell.
Yes, I Paul. Yeah, just refer, and just pointing out that my first point was more an observation that your perspective may not be a neutral one. But I'll move on to the question. Look, I sent a document to our CEO entitled Draft JMA Scope Beyond Act, which was forwarded to me and identifies a number of clauses where this JMA is apparently going well beyond the requirements of the 2010 Act. Look, I had requested for a written response before today, but since that didn't happen, could I now ask you, please, to directly respond, even in principle? Well, I'm hoping you might have seen the document anyway, but can you confirm which, if any, of those extended clauses are legally required and which are simply a matter of political choice or negotiation?
Thank you, through your worship. Thank you, Councillor Campbell. So, yes, well, as I said earlier, the Act expressly contemplates that there will be extensions beyond. So it's the Act, the legislation is structured in a way that it has compulsory content and then extended matters, and it's in that extended matters list that I have seen. Thank you very much for the document that you have forwarded. I have seen that. There are some matters I don't strictly agree with, but yes, the document is correct that they've identified a number of areas where there is agreement to move beyond the compulsory matters, but that is that's the intention of the Act, and in fact is widely adopted elsewhere. So if you go and look at the Money Portal 1, there's Local Government Act, Reserves Act, all of these matters are covered in that one as well. So I certainly do not agree if the suggestion is that those are unlawful, but they are extension matters. So yes, I certainly accept they are beyond the compulsory matters, if that's helpful.
No, thank you for that. And you may have discerned by now that it's kind of the extension matters which have been the cause for disagreement. Thanks.
Thank you.
Councillor Foreman.
Yes, I'll just checking. I would like a response to my question that I've already asked, but also, Paul, in your legal opinion, have we actually complied with the legal framework to execute the JMA, or are there areas that we could work on going forward?
Thank you. Through your worship. So my view is the agreement that was going to be that was proposed for signing did comply with the legislation. Again, Sue may be able to clarify the timing point in terms of when notice was given and what date we're up to. But so to answer your question, in my view, it was lawful and it was consistent with the legislation. And there would be scope to, obviously it hasn't been signed yet, so there would be scope to deal with further matters if you wanted to. But certainly when it was put up for signing, there had been a very detailed and rigorous process worked through to get to the form of that agreement. I hope that answers your question, Councillor.
Councillor Foreman, are you happy with the answer?
Yes, thank you, Paul.
Thank you, Councillor.
Councillor Murch.
Yeah, I just wanted to query on the extension. Are there any legal implications there for excluding the moana, Taupo moana, from the JMA from a treaty and te tiriti perspective?
Thank you. Through your worship. So, thank you, Councillor. Yes. So I guess if I could just yes, I'll try and respond to that in a couple of ways. But firstly, the strict legal position is there isn't a choice for the council and for the trust board as to whether Taupo moana is in. I think if it were not to be included, given it is such a significant part of the district, you would then, the council would find itself in a position that it would have a whole lot of legal obligations to comply with in relation to the moana, and it would have to work out how to do that. So it would have one agreement applying to part of its district, and then it would have a whole lot of other legal obligations, like into relation to RMA planning, local government planning, Reserves Act, all sorts of other statutory obligations, and there would be some risk that the council would not be complying, may not comply with those obligations, and it goes back to my point about clarity and consistency across the district, particularly for a place of such significance in the context of the geography of the district. But and then just separate to that, if I may add, the question about how the council, because the council, for example, currently under legislation has obligations relating to the Treaty of Waitangi in relation to Taupo moana. And without the agreement covering Taupo moana, you've got the live and open question is how do we comply with those? What does that mean? What does it mean for our council staff every day working? And so that's why there is some attraction to a holistic agreement that covers the whole area, that brings some clarity to that. And the council can have confidence that the trust board is comfortable that that's the way in which, say, the treaty provisions apply in that particular area. But it is a complex area, so I'll just give you a summary answer if I may. Thank you.
Thank you.
Councillor Cameron.
Thank you, Your Worship, through you. Sorry, just on that, Paul, can I just ask for some clarification? Initially, when the paper was brought to us in September of 2024, the resolution asked us to consider extending from the strict upper Waikato River to Waikato waters as part of that resolution. From there, it came back as Taupo Moana. Could you please just describe the difference between Taupo waters, which I understand is in the deed of settlement, and Taupo Moana?
Yes, I may need some assistance from the council team on this. So, because there was a progression of briefings, but there was also a progression. Itself actually explains why there was a preference to move away from Taupo waters, and because that was a term that was used really in the original vesting and original agreements with the Crown in 1992, 2007. But there's in 28 there is a 28 of the agreement. There's an explanation of why it's moved to Taupo Moana and the Upper River, Waikato River description. But it may be. Sorry, I'm sorry, I'm not trying to avoid the question. It may be that the council team can. And there's a map that's just come up to show the Waikato River catchment and then the Taupo Moana catchment.
Sue, do you want to speak to that, explain it to the audience?
Yes, I can. The northern part of that, so the part that's called the Waikato River catchment, that's the area that's required as a mandatory area to be included in the JMA. So the JMA must, the mandatory parts of the JMA must include that area. And then what we did was we extended it to cover an area of what we called Taupo Moana. Taupo Moana is greater than Taupo waters. I have got a map showing Taupo waters, which I can find quickly and show you. But the area, the bottom area, the large area around the lake, is essentially the catchment of the lake, and that's what we called, that's what we've added to the Waikato River catchment to call Taupo Moana. And the reason for that was that the water that flows from the tributaries to the lake into the lake then flows down to the Waikato River. And the purpose of the JMA is about protecting and improving and enhancing the Waikato River, and that's a very good way to do it.
Sorry, can I just supplementary question there then? Because I was of the understanding that Taupo waters covered the lake and the tributaries into the lake, and then Taupo Moana was an expansion of that scope.
Well, if I may, we clearly today was about the legislative background. If that's an area of interest, I wondered whether that's a briefing topic in itself or a topic that we can specifically cover when we're looking at the additional matters. Yeah. As you can tell, we're just probably doing this a little bit.
Oh, it was just a reference to Taupo Moana. I just wanted to get that clarification clear of what the area was. Yeah, thank you.
If I may, while I've just got the microphone, in terms of Councillor Foreman's question, it was February 2020 when we received notification from the Trust Board seeking to enter into a JMA. And just to add to that further, there is that information, and the timeline of events was outlined to Council. We can provide that information as well. It was included in the Council paper that went in the last training, which I believe is also up on our website, so the public can see that too.
So just a reminder, this is about the legislation, the Act itself. We're starting to sort of veer into the other areas which are going to come up later in the series that we're running.
Taupo Waters is in the Act, and so if it helps, I've got the slide that shows it, and Taupo Waters is water, not catchment. So there's your difference, but I have got a map if it, will that come up? I'm plugged in. No, it's not. It did it just now. How weird. Oh, something's happening. Oh, I see, because I've got... Ah, well done, thank you. Can you make it a bit bigger? Is that possible? possible? Great, thank you. I'm not an expert on Taupo waters, but Taupo waters, and some of our councillors may well be, Taupo waters covers 3 property titles. The blue one, which is the bed of the lake, the purple one, which is part of the bed of the Waikato River, and the red ones, which are the beds of some of the tributaries that flow into the lake. That's what Taupo waters actually is. Taupo moana is something quite different because it's the whole catchment, not just the waters, the whole catchment of the lake.
No, I was just going to ask, who owns the bed of the lake? No, genuinely. Who owns the bed of the lake?
Oh, well, oh, yeah.
The Trust Board owns a bed of the lake. Yep.
Yeah. Oh, through the chair, yes, I thought maybe Paul can. I'm just interested in going back in time, 2009, 2010, because I think you said you had something to do with. You were involved in it back then. No, well, I mean, I can see the logic in throwing in the lake there because that's the origin of the Waikato River and it's sort of all waters related. But I'm just interested. Well, if it seems to make so much sense now, well, why didn't that occur to the authors of the original 2010 agreement that to do it then?
Thank you. Yes, through your worship. So, no, look, I was involved in the negotiation of all of these Waikato River arrangements and the drafting of them. So what I recall at the time was that the Trust Board wanted the optionality. It had some good relationships with councils, and it was anxious to ensure that that decision could be made down the track. So also the negotiations were about the Waikato River, but it was negotiated in that could be extended to Taupo waters if both the Trust Board and the council agreed. So so it was obviously Taupo moana is the the source of the river, but it is not part of the river in that sense. So it wasn't included. These were Waikato River negotiations at the time.
Yeah. Okay, thanks.
Are there any further questions from the councillors? Councillor Woodward.
Thank you, Your Worship. Just a question, how does the legislative requirement help us achieve long-term protection of the moanas Māori in a way voluntary arrangements couldn't?
Thank you, through your worship. It is it's because it's a statutory requirement one thing that the settlement legislation didn't do, or the legislation didn't do, was to it created an opportunity for the parties to come together and work together on this, and so it's got the long-term security of being in legislation, therefore it gives the agreement long-term security, and that's really important in terms of the parties being able to take a long-term planning horizon together and say, how do we make sure we are looking after this water and this place over the long term. With voluntary agreements, of course, people can pull out of them, and so that it makes them it makes long-term planning and approaches a bit more challenging. Thank you.
Any further questions from the councillors? Paul,
Sorry, I just had one more. Just thinking about long term, if both parties were to enter into this agreement, does the legislation allow technical amendments to be made without having to reopen the entire agreement?
That's a very good question. To agree to review the agreement and agree to amend it, but there's no particular formality required about that. It's just needs to be agreed in writing between the two parties. Yeah.
Any further questions from the councillors? Paul, you must have done a pretty good job. We seem to run out of questions. Is everyone sure with regards to this piece of legislation they've got all the answers they need?
I'm not sure if this is within the scope of today's workshop, but just following on from that. So if we reach an agreement to extend and then legislation is passed that may require, but that might, like the reforms, are we not required to comply with that? Is that what we have to agree in order to comply with that change of legislation?
Through your worship, no. So thank you for the question. So if there's law reform and the legislation changes, there will be a process, and that may be provided for in the legislation, where the council and the trust board will work together to reflect any new legislation and new legislative regimes. There was a previous set of reforms, as you may recall, and that may have had to happen around the country after those. But after this agreement is signed, if the new RMA systems take effect down the track, which will, they may come into effect next year, but they will take some time to implement, then it's likely that you'll have to revisit certain aspects of the agreement and say, okay, how are we going to reflect and update to reflect these new arrangements? But there'll be the many agreements around the country will be doing that.
Yeah, I guess the question I have is, do we need to agree on that? And if we don't agree, is that when it goes to the minister? Is that the process?
The ministerial referral process is really about entering into rather than amending the JMA. So this is something that the government should provide some clarity through their reform legislation, but there are dispute resolution processes that could be referred to if necessary if the parties can't agree.
Thank you.
Councillor Campbell.
Yes, Paul, I mean, correct me if I'm, this is my understanding, interpretation anyway. In theory, within the agreement, there is scope for amending the extension items, subject to mutual agreement. But my interpretation of this is once this ball starts rolling, that would be, in practice, quite hard to make come about, actually. So I think sometimes, in my understanding of it, it is to be, it's somewhat flippant to say that anything can be sorted down the track. I don't know if that's a question or not, but there you are.
Well, through your worship, thank you, Councillor Campbell. Look, during the life of these agreements, there are all sorts of changes that could come along, and in the spirit of the kind of agreement and the provisions in it, the parties, for example, if there's a provision in this agreement that relates to a piece of legislation that no longer exists, the parties are going to have to come together and agree how to replace it, just as they have to agree how to enter into it. So I have some confidence, people, because otherwise you're not connecting to the actual legislation in place. So I've confidence that will, the parties will need to come together and deal with it.
Thank you, Paul. Are there any further questions from around the table of Paul on the legislative process? Councillor Greenslater, you can hear us here. You got any questions?
Thank you, Your Worship. I do have one question. Thank you, Paul. That's been extremely interesting. I did read the original Act and read all the submissions on the original Act. Taupo District Council made submissions at the time in the 2009 consultation process. Are you aware of those submissions and whether they've been answered?
Thank you, through your worship. I recall what was going on at the time. I don't recall the exact nature of the submissions, and I don't recall whether they were answered in the legislation itself. But obviously, once the legislation's taken effect, then I think as you've mentioned, then those are the provisions that apply to this arrangement. But I do recall sentiment that the relationships between the Trust Board and the councils were very positive at the time, and I'm not saying they're not now, but and so therefore that's why there was optionality built in so that the parties could make these types of decisions down the track, in part. Yeah.
So following on from that, because we've got extension matters underway, is it going to be appropriate for submissions to be made on the extension matters?
Through your worship, I'm not sure quite. So when you,
Well,
do you mean on new
question-
legislation or?
Well, the thing is, I suppose in the original legislation went through Parliament, it went through a submission, it went through the parliamentary process, which of course is select committee and submissions. So because we're now introducing additional matters, do you think there's an opportunity for people to submit on the additional matters, which of course weren't there in the original legislation?
Through your worship, I think that's probably a matter for one of your subsequent workshops, councillor. But what is in the original legislation is the ability to agree extension matters. So I think that was clearly there. But I understand that'll be a matter that's dealt with in a subsequent workshop.
Yeah, just to reinforce that point, Paul, and to respond to you, Councillor Greenside, thanks for the question. And refer back to the beginning, there was a series of briefings I put on the board, and one of them was around community engagement. So I appreciate that question, and we can dive into that a little bit more in depth at that point too. So thank you for that.
Thanks, Geraldine. Thank you very much. That's all. Thank you, Paul. Really great. Enjoyed that. Excellent and very, very clear. Very great clarity.
Thank you, councillor.
Are there any further questions from around the table?
Sorry, just one last one, I promise. I was just thinking, what are there any statutory protections in place that can be exercised if we don't reach a consensus here?
Thank you, through your worship. So there's the escalation process to the minister, which can be dealt with in a later workshop as well. So that, and of course there's legal action as well, because there's a statutory requirement to enter into this agreement. But that would probably follow in that order. Firstly would be the escalation process to the minister.
Any further questions from the table? Paul, I think we've probably reached the end of it. Thank you for making the time available and answering those questions and the odd statement. I appreciate you making the time. We look forward to working with you in the future.
Thank you very much, your worship, and wish everyone the very best for the last few days of the year. Thank you.
Thank you. Julie, did you want to? We'll now have the closing karakia.
Unihia te rito o tēnei hui, kia wate e runga, kia wate e raro, aro ki te tika, aro ki te pai, hui e tai ki e.
Thank you everyone and the public for coming along and learning with us.